This public hearing of the Parliamentary Joint Committee on the National Anti-Corruption Commission for its examination of the Inspector of the National Anti-Corruption Commission's annual report for 2024-25. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to elders past and present. I extend that respect to any Aboriginal and Torres Strait Islander peoples present today. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. Before we begin, a brief word on the role of the committee. The functions of the committee are set out in Section 177 of the National Anti-Corruption Act 2022. These include examining the annual reports of the Commission and the Inspector. The committee also has a role in relation to reviewing the budget and finances of the Commission. This hearing is also an opportunity for the committee to undertake more general functions under Section 177, including monitoring the performance by the Commissioner and Inspector of their functions and examining trends and changes in corruption among those who are subject to the Act. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The committee generally prefers evidence to be given in public, but witnesses do have the right to request to be heard in a private session. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. The committee has set 20 January 2026 as the date for responses to any questions that are taken on notice. I now welcome the Inspector of the National Anti-Corruption Commission. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, can you please state your full name and the capacity in which you appear today?
Thank you, Chair. My name is Gail Barton-Furness and I am the Inspector of the National Anti-Corruption Commission.
Thank you. And I understand you don't have an opening statement, but you did want to update the committee about some errors in your annual report.
I do, thank you. On the table on page 5, there's a reference to the number of NAC corruption issues dealt with and referred, and each refers to paragraph 9.5 and each should be 9.6. And secondly, there is a typographical error on page 24 of section 12 where complementary is spelt with an I rather than an E.
Thank you. That is very thorough.
Very important.
That's right. We appreciate attention to spelling at this committee. Inspector, I will ask a couple of questions and throw to committee members. Having looked at your annual report, one of the points that stood out for me was possible concerns around how long it's taking for investigations to be triaged. I see that you received 19 complaints about the time taken by the NAC to make a decision about a referral. Can you tell the committee about what you have observed in this space and if you have concerns?
Well, given that this is my second annual report, the Commission obviously has referrals from the first and second year. So there's a number of referrals in the pipeline, if you like, so more now than there were initially. The concerns that are expressed to me include they receive sometimes no acknowledgement of the complaint or referral in the first place. Some of that, I think, has been fixed in that there's automatic acknowledgements if you provide a web form, but that's an issue. The second issue is that even if they do get an acknowledgement, it's some time before they find out what, if anything's happened, and usually that's prompted by them inquiring as to progress, or indeed me on their behalf inquiring as to progress. And even if they get information at that stage, then it can be still several months before any outcome is provided. So it's the delays along the way of the triage and assessment process. And if the matter proceeds to a preliminary or full investigation, they're generally not told, and for some people that's problematic.
Is that an issue that people are raising with you, that they are not hearing progress reports through that and have people raised the implications of that for them?
Quite a few people have said to me that the matter they've referred is sensitive to them, and so delays in not being advised as to progress and the like has affected their mental health, and I've certainly conveyed that to the Commission in turn. So yes, certainly many referrals are very important and sensitive to the individual making them, and it can exacerbate existing conditions. So that certainly has been raised with me on a number of occasions.
I know you fulfil a similar role for the New South Wales Anti-Corruption Commission. Based on that experience or broader observations, do you have observations for the NAC on how they could improve that process?
Well, along the way over the last couple of years, matters have arisen from complaints, and I've made suggestions from time to time, and often those suggestions have been well received. They've included matters like involving lawyers when there's a real jurisdictional issue involved, considering more complex complaints along a different, perhaps, pathway than others, considering the mix of experience and a skill set in triage and assessment teams, those sort of matters. In New South Wales, in the ICAC, they generally would complete assessments within 3 months, and so there's never really an issue, as they tell me and as I observe there, for communicating in a timely way with complainants, as they're called in that jurisdiction.
Do you think it is understandable that a new body like the NAC is taking this length of time to resolve issues, or is timeliness of investigation something that they should be considering further?
Well, I know that in their annual report and in recent evidence, the NAC indicates that they're meeting their KPIs in respect of the 90-day period in which it responds to referrals. And that may well be the case. So what I'm receiving are obviously part of the 15% that's remaining. It is newish. It's 2.5 years. They clearly took over an existing body, which I'm sure would have had some triage and assessment process. There are many bodies in the Commonwealth and the states that deal with referrals or complaints or public-facing material, if you like. So I don't know that I think there's a lot of material out there from other agencies advising as to how this works best. But ultimately it's a matter for their processes as to what they set up. However, people do come to me to complain about matters taking, in their mind, too long.
Okay. I'm mindful of other committee members having questions, but I also wanted to touch on conflict of interest. I think in your report you said, I think you received 4 complaints about the Commissioner having a conflict of interest regarding referrals to the NAC about defence or the ADF. How would you characterise the level of concerns that are brought to you about conflict of interest matters at the NAC?
We're referring to my annual report, which clearly finished on the 30th of June 2025. Since then, there has been a significant greater number of complaints, and which is hardly surprising given the various matters that have been raised in the media and elsewhere. So now it's a significant component of the complaints I have. So if you're looking at post 1 July this year, I've received in the vicinity of close to 90 complaints about the 3 issues that have been in the subject of public commentary. That is the Commissioner's connections generally with the defence. Secondly, the Commissioner's ongoing role with the IGADF. And thirdly, the question of the procurement of counsel assisting. So those 3 matters combined have given rise to that number of complaints, compared with about 38 other complaints I've received in the 5 months to date of this financial year, and they reflect largely the complaints I received in the last 2 years. That is, complaining that the Commission didn't investigate a referral, complaints about timeframes, communication and that sort of thing.
Can you update the committee on what you are doing with, or what you intend to do with the complaints you are receiving around conflict of interest?
Certainly. I have asked the Commission to provide me with information covering those three topics I mentioned, and I received the bulk of it last Friday evening, and I received the rest of it yesterday. And there's a significant volume, some 400-odd documents, but obviously running to, a couple of thousand at least pages. So I propose to review those documents, and I have engaged, as I've indicated before, to Council to assist me.
Sorry to interrupt you. I've just got a technical issue with your evidence running on the website. Apologies. I just was cutting across.
Oh, that was okay.
Sorry.
Thank
Apologies.
You. Sorry, Inspector. Continue.
So I have that material. I'm reviewing it. I anticipate that there will be further material I will need, and then I will anticipate that I'll be discussing my findings, observations with the Commission. So that's the timeline. The date where it ends, I don't know, but months, not weeks.
That's a significant investigation. I'm conscious that one of the functions of the Commission is to not only investigate corruption but to assure the Australian public that these matters are attended to, and that we do have an independent watchdog. And in that light, receiving 90 complaints from members of the public concerned about conflict of interest, I do find that concerning, because it suggests that there is a public perception that the NAC is not being independent when it does its role. Is that the type of complaint that people are raising with you, that they do not feel that the acts of the Commission are independent?
The commentary I receive ranges to personal insults to systemic and policy matters. But generally speaking, the approach of those to me is that their sense of trust and faith, if you like, in the corruption agency dealing appropriately with defence matters is diminished by what they see and read about defence connections.
Okay. Deputy Chair, do you want to ask some questions?
Yeah, thank you. Thank you very much, Inspector. I might just continue on the theme of the National Anti-Corruption Commission's responses in regard to the Commissioner's conflict of interest issues. I noticed that it's been added as a new category in your annual report, and the evidence you've just given us indicates that post this annual report, it looks like there's more than double the number of complaints relate to this perception of conflict of interest in relation to any other complaint. Is that right?
I think it's fair to say that it's the source of material in the media that has resulted in people complaining to me, because the complaints have been based on some of the documents that have been accessed via FOI and published by the ABC and the like. So that seems to me to be the source of the complaint rather than other independent source of information from the referrer. There's some exceptions to that, of course. I'm not sure if that quite answers your question.
Yes, no, it does. In regard to the complaints that you receive around conflict of interest, are there any other conflicts that have been identified by the complainants outside of the ADF connections with the Commissioner?
No.
Okay. Since this has come to light, Commissioner Brereton will now recuse himself from all matters relating to defence and the ADF. Do you consider that to be an appropriate safeguard?
The complainants to me are asked when completing the web form what outcome they would like from their complaint. And one of the outcomes that many people have referred to is that they would prefer the Commissioner not to be involved in assessing any defence matters. So, based on what I've been told, that should have a positive effect.
Do you, in response to those people, now that there's been this decision made by the NAC that the Commissioner will recuse himself from ADF, how do the people who complain to you find out about that? Do they rely on the media, or does your office now respond to them?
They rely on the media. I certainly haven't made anything public about the Commissioner's recent announcement. It's on NAC's website and it's been widely reported, and it's reported on social media. So I can't think that I've had much commentary since then directly to me, although I've read it elsewhere.
Okay. What would be your recommended course of action, learning what we've learnt from what's happened over the course of the NAC's beginnings and this conflict of interest issue? Is there something that you've learnt from this that you would recommend was changed about how the NAC manages conflict of interest or perceived conflict of interest?
The Commission recently published a guide on conflicts of interest, which had been, as I understand it, developed in consultation with a range of Commonwealth bodies. And that document is, to my way of thinking, very good in setting out in some detail what conflicts look like and what management looks like. And if that document had been in place at the beginning, then it may well be that the approach taken was more robust consistently with that document and the principles and steps set out.
Does it surprise you that such a document didn't exist at the beginning of the National Anti-Corruption Commission?
Well, there were documents like that. I mean, the ICAC has an excellent conflicts of interest policy which drills down into detail such as, do you go to each other's house? Do you know the name of their dog? That sort of thing. So it's not that they didn't exist before, but looking at this document now, if one was to, in good faith, follow the principle as well as the spoken words or written words, then you would have a more robust approach, to my mind, to conflicts of interest. To put it in plainer words, if there's a conflict, just stay away from it. Don't get the materials. Don't go to meetings. That sort of thing. And perhaps I can add, because this is part of the Robodebt report, the then Deputy Commissioner Hinchcliffe, she declared a conflict in relation to the Robodebt matters and just refused to accept any documents or to attend any meetings. So she stayed completely away from it.
Thank you. Chair, I'm conscious there's others.
We'll go to Senator Shoebridge.
Thanks, Chair, and thanks, Inspector, for your attendance and your work throughout your appointment. And I'm sorry if we might revisit some matters that were discussed in the estimates hearing. But when you talk about a more robust approach on conflicts of interest, I think you partly described it then, which is you just take a very firm line. If there's a perception or an actual conflict of interest, well then to protect institutions, you just take a very firm line and have no part in it. That's really at the core of it, isn't it?
I think the words you've used, to protect the institution, are important, because primarily what you're doing is protecting the decision-making process and people's belief and acceptance in the decision-making process. That's why you're doing it. And for me, to just leave or not to be there in the first place, you could have, if for example, there is a line of referrals that are consistently made and that a person has a potential conflict with them, you could deal with them in a separate meeting. You could just remove them from the process and have a separate pathway. There are a range of ways you can do it, but certainly to my mind, leaving the room can be an appropriate way of dealing with conflicts which are somewhat remote, but to my way of thinking, for the decision-making process to be robust and well considered by external forces, don't be there.
And the Robodebt example was almost Exhibit A in that regard, where the Commissioner sought to be involved in a lot of the referral, and exiting the meeting at the final decision-making point, that blurred the lines. And, I'm not going to revisit all of your report, but that's almost like Exhibit A, isn't it? We're not taking a firm line became a problem.
Well, I think Robodebt shows you that just leaving the room is not enough. If you participate in the discussion and give your views and write what's needed for legal advice and comment on the legal advice, leaving the room really is to no effect or little effect.
Many people have contacted my office and they point out that the NAC says that one of its primary targeted bodies of work is addressing conflicts of interest in the public sector. And they've expressed to me, and they may well to other members of Parliament, that the failure of the NAC to deal with its own conflicts of interest really brings into question their ability of the NAC to show that kind of leadership. Is that part of the complaints that are coming to you?
Yes. Yep. Yes, they lose faith more generally, not just in the defence matters. That's true.
Yeah. Could I ask a bit more specifically about the decision that the NAC Commissioner communicated, I think at the end of October of this year, to recuse himself not just from a small number of defence matters where he'd had an identifiable personal connection with units or people, but to recuse himself from all matters. Has the Commissioner given you details about what that has involved in relation to those other matters?
Not in that context, but in the context of my inquiries, I have sought and received information about the number of defence-related referrals since the commencement and the number of those about which there was a recusal.
Because, to just take the Robodebt example, initial decisions about the scope of inquiry, trains of evidence that might be pursued, the resourcing of inquiries, those can be as critical to an investigation as, sitting in a room at the end of the day assessing the final body of evidence. That's my understanding of an investigation. Those initial steps can be as critical as the final steps, can't they?
Well, they can, and the concentration to date has been on assessing a defence-related complaint, not necessarily on what happens after it may have been assessed. This is particularly ones in the past, and the conduct of the investigation. Now, I'm sure the Commissioner can tell you what he is doing in respect of those matters which have been assessed in the pipeline before the end of October, what he has done in respect of them. I have some information, but it's certainly not complete enough for me to provide you with that answer.
Yeah, but to the extent there are concerns about the inspector having an actual or potential or perceived conflict of interest... Sorry, I'll start again. Inspector, to the extent that there are concerns of the Commissioner having an actual or perceived conflict of interest in defence matters, if the Commissioner has been deeply involved in a matter for a period of time and then pulls himself out afterwards because of the decision he's made in October, can you unscramble the egg if he's been involved in it for months or years before then?
Well, I think that's probably fact-specific, as we say. It would depend on the circumstances. There are 3 Deputy Commissioners, each of whom have been appointed to, perform those functions. So I would rely on each of those Deputy Commissioners to ensure that appropriate steps were taken in respect of the matters you refer to. Because
I know other members have time, I might just ask for your... I think both the Chair and the Deputy were asking you to sort of reflect upon your experience as the ICAC inspector compared to the NAC inspector, and you probably remember some of those questions. One of the issues is obviously timeliness. You say that the New South Wales ICAC determines all initial referrals within 3 months and they meet that target. That's certainly the advice they gave to me when I was inquiring to form a comparison. Yep. Do you have any sense of the sort of volume difference between the number of corruption matters referrals that go to the New South Wales ICAC compared to the number of corruption referrals that go to the NAC?
In the first year of the NAC's operation, it received about 3,000, I think, and the ICAC received something like 3,500. In the second year, I think NAC dropped to the low 2,000s. I mean, this is all information available on the public record. And I think the ICAC remained at about 3,500. Now, I might not be absolutely precise, but generally speaking, the ICAC has received and receives more referrals.
So if there was an argument that, it's because of the volume of complaints coming to the NAC, just that bare numbers analysis compared to ICAC would suggest that it's not volume driven. There are other organisational issues that might explain the difference in timeliness.
Well, I think in my annual report I referred to a complaint that I received about timeliness, and I have included in it, this is case study 3 on page 20, I've included in the last paragraph of that box the NAC's advice to me about the delay, and it was quite egregious, the delay in that case, was due to, quote, staffing shortages, the transfer of the referral between officers and competing priorities. And it indicated that there was being implemented a new prioritisation matrix, which would make it different next time.
Yeah, and I note that reported in the Australian today is another case of a complainant who had a history of complaints which were not dealt with the AFP. And again, another story of seems to be unconscionable delay causing very real personal distress. Is that complaint about the personal distress that the delay causes, is that a feature of some of the complaints? Look,
it is a feature of some of them, but one has to reconcile that with the fact that they're meeting their KPIs. And so, I mean, it's obviously questions for them as to if they're meeting the KPIs of 85% in 90 days, what is the 15%? Are they the sort of complaints that I'm receiving and from what you say you're receiving? How is it determined which is dealt with earlier than, not? They're matters for their management of their triage and assessment. But it's certainly the case that I am receiving complaints about people expressing personal distress at the lack of what they consider to be timeliness.
And as you rightly point out, your role as the inspector, you're inevitably going to have that cohort of complaint, and perhaps we should ask that broader picture of the NAC.
Yes.
Yep, thanks.
Thank you, Senator Henderson.
Thank you very much, Chair. Good morning, Ms Furness. Can I just ask, at estimates last week, you indicated you were waiting on information from the Commission in order to progress your investigation into the Commissioner's defence recusals. Could you just update the committee on whether you've received any such information?
Yes, as I indicated, I received a lot of it on last Friday evening and I received the rest of it yesterday. So I've received, I think, all that I've asked for, but I have no doubt that reading this material will give rise to more questions.
Are you able to furnish the committee with that information?
The information being what I've received?
Yes.
Well, I could. I'm not sure that it's going to be useful for you to receive 400 documents, each of varying length.
Outside the scope of this particular inquiry, but was something we could ask the inspector about the information.
Happy for you to take that on notice and consider
Senator.
that. I'm just wondering to ask you, are some conflicts so entrenched that any official of the Commission should not occupy two roles? And I guess what I'm asking, in light of the issues with the recusals by the Commissioner in relation to the IGADF, is it appropriate that he continue to occupy that role?
the
with
role.
the IGADF?
Well, as I understand it, the advice that he has been and will presumably continue to give the IGADF is in relation to a confined issue about which he has obviously knowledge. And I think the Parliament, through one or more committees, understands the frequency with which he has done that and when he has done that. It's clearly a matter that was addressed by the then Attorney-General because there is the letter which refers to it. Whether or not he should continue in that role is not, I think, a matter for me. What is of interest to me, because this goes to the heart of managing conflicts, which is something that is within my purview, is to whom that has been disclosed.
And so you don't regard Commissioner Brereton's continuation in that limited role as an inherent conflict of interest?
It's how that conflict is managed that is of particular interest to me. The management has changed since the end of October in that the Commissioner has said that he will have nothing to do with defence matters, and it's certainly the case that he had in previous declarations referred to an affiliation with the IGADF. Whether or not that covers the advice role, I'm not sure. I don't think it's a matter for me to say what work he should or shouldn't be doing. It's a matter for others to perhaps comment on. But for me, my issue is how is a conflict managed, because there will inevitably be conflicts that arise from time to time for many people. It's the management of those conflicts which begins with identification and disclosure. And so for me, in relation to the IGADF, there was one disclosure, apparently to the then Attorney-General. The question is other disclosures, and that's part of the management process.
Given that is a principal concern of yours, I guess I just want to press that point. Do you consider that the dual roles occupied by Commissioner Brereton are compatible with his primary role as Commissioner of the NAC? I understand the point you're making about the management of conflicts, but isn't it the case that some conflicts are so entrenched, I'm asking this obviously as just a general proposition, that it's practically too difficult to be juggling both roles? So, I mean, I would just put to you that I think perhaps, Ms Furness, that is within your remit, given your very significant concern in terms of dealing with conflicts of interest.
The conflicts can be managed in many ways. One way you can manage a conflict is to remove one of the duties or areas of work. That's one way of doing it. And if one was to take the approach in relation to your matter, that would be how you'd manage it, not do one of the roles. But then there are a whole variety of other ways you can manage conflicts short of doing that may still have the desired effect, which is, as I indicated before, this is all about confidence in public decision-making. That's the heart of this.
Isn't it the optimum position, though, where there is these ongoing issues of conflict of interest, that the best outcome might be for the Commissioner to no longer fulfil or continue with his responsibilities with the IGADF?
Well, that would be one approach. Whether it's the only approach and the best approach is another matter. But to me, there needs to be public confidence in the decision-making of the Commission in respect of all matters, including defence. And if that can be achieved by recusing himself from all defence matters, then that's a desired outcome. I'm not entirely sure that the approach that you're asking me about is the only approach to achieve the desired outcome of public confidence in decision-making.
No, I appreciate that. Look, I just want to ask about the Commission's public investigation reports, the published investigation reports. Firstly, how effective do you think they have been in terms of those reports which have been made public?
Well, as I understand it, there's only been one full report that's been published, and that was Operation Kingscliff, just before the end of last financial year, which concerned a Home Affairs public servant, and there were findings made of corrupt conduct. As I understand it, that's the only published report of the work of the Commission in respect of findings. There have been various matters published on the website about investigations that have not proceeded for the reasons given. So in terms of the effectiveness of the Home Affairs report, it certainly covered nepotism, which the Commission has identified as one of the areas of concern, and it was a report that's available to be read and to understand the corruption prevention implications, if you like, of it.
I just want to refer to the public statement made by the Commission on the 12th of June 2025 in relation to the settlement between Ms Higgins and the Commonwealth, which obviously has been reported at more than $2.4 million. Now, no finding of corruption was made. That was a preliminary assessment only, and there was a full statement made about that. Given the decision made by Justice Tottle in the WA Supreme Court since that preliminary assessment was made public, I'm wondering whether it's appropriate for that matter to be revisited, because we have learnt now a lot more about that particular matter. Without going to the substance of the matter, I'm not asking you about that, but I'm talking about the process.
Well, I think that's a question for the Commission as to whether it considers that there's additional information available that's relevant to its jurisdiction, and whether, if so, it should reopen the investigation. My role is not to tell it what to investigate and what not to.
Yes, that's why I was very careful to say I'm asking about the process.
Senator, we have other members waiting, so one more question.
Yes, sure. So do you have any further comments to make in relation to the process adopted in that particular determination?
No, I don't.
Thank you. Thanks, Chair.
Thank you. Dr Garland?
Thank you so much, Chair. And look, I'm not going to talk about any particular matters or, ask for positions on issues in the public domain necessarily. I'm kind of just interested in understanding where you think, in terms of public confidence, there could be improvements. So thinking about things like timeliness, about workforce issues, about where there could be more capacity in the system. What do you think, from what you've seen so far, would help with public confidence and help with, those kind of timeliness considerations with the NAC?
Well, from the information I receive as Inspector, there are a number of ongoing issues that affect individuals' sense of confidence. One is accessibility. The Commission doesn't have an email address for the reasons I'm sure they can tell you about, but the effect is that I get a lot of emails because I have an email address, and that are meant to go to the NAC but come to me, but more generally. So that's an accessibility point that people complain to me about. There's limits to the information they can upload. There's problems with telephone calls being returned. There's inconsistencies with website and what actually happens. So there's a range of accessibility which frustrate people. And so that could, they are areas for improvement. Reasons, there's no obligation to give reasons. Sometimes the reasons that are given aren't readily understandable by some of the referrers. For example, a number of people are told there's no viable hypothesis of a corruption issue, which people probably not surprisingly struggle with. Now, I understand that volume issues and tailoring letters is time-consuming and resource intensive. I understand that, but if people received better reasons, I suspect few of them would come to me. So they're sort of quite basic, if you like, areas that have come to my attention.
Thank you for that. And just reflecting on as well some things from the annual report. In terms of workforce, do you think that there are enough people, I mean, and you know, in that triage area as there should be, and what skills do you think that, you know, the Commission should have that would really help with capacity?
Well, it's a matter for the Commission how it manages its cells and organises its resources. That's primarily not my concern. But nevertheless, I understand that it's been a regular issue over the last couple of years, retaining and attracting staff in that triage and assessment area. And the quote I just read recently indicates that as well, that there have been staffing shortages. So that's a question of, you know, whatever process they use to recruit and retain people, which I'm sure they can talk about. As to the appropriate skill mix, again, that's a matter for them, and there are many agencies that do this sort of work, so it's not as though it has to be thought of from scratch, and it may well be if there remain problems in that area, advice can be sought from other appropriate bodies. But given that triage and assessment is a core part of the work that I do in respect of complaints, to me, ensuring that you do have the appropriate skill mix and level of experience, as well as obviously number of staff, would work to improve, one would have thought, timeframes, accessibility and the like. Having said that, my job is not to manage the Commission.
Of course, thank you so much.
Senator Darmanin.
Thank you. Can you hear me?
Yes, we can.
Great. Thank you for your time this morning. And one of my questions I think you've partly covered in response to Dr. Garland just then, just in terms of some of the kind of areas of focus that could continue to be looked at. I guess one of my first questions was just, given your experience with a similar organisation in New South Wales that is, you know, a lot further developed, and noting that we're still only a couple of years into the operation of the organisation, have you got any kind of additional broader insights to share with the committee about the performance of the NAC that you would expect to be a little further along the track by now than they are, that you haven't already mentioned?
Well, the NAC frequently says that corruption investigations take time, and that's why they have completed fewer than perhaps public commentary would suggest they should have. They would also say that they've taken over from ACLI, so there's a number of legacy matters that they're dealing with. I think the issue with the ICAC in New South Wales is obviously it's been going for many, many years, and it has a very well-established system of operating, but it has public hearings, and it has public hearings if they pass the public interest test, and that enables people to see and hear and evaluate what they're doing. So I think people have a different view because of that. Now, the legislation is different in the Commonwealth, and I don't know whether that has any impact on what people think as the volume or timeliness of the work the NAC does. But investigations do take some time, they're quite right. And as I understand it from the ICAC work, they're more complicated, there's more information available. The use of various surveillance, techniques means that instead of getting thousands of documents, they now get significantly more, both documents and, various digital forms of information. So I accept that it takes a long time. Is it too long? It's hard to say from the outside. It probably would be better one would be better placed to comment on it after an investigation is finished to see the timeline, and then you could perhaps form a view, if you wish to, as to the time taken. But it's difficult for me to say anything more.
Yeah. So, and what about in terms of operational governance and sort of performance management of the organisation? Are there particular areas of focus for you in that regard? I guess things like proactive communications and engagement, thinking about what you've just said then around, what the public perceptions are in terms of their operations. What would you say about the governance in the operations of the organisation and performance management in general with those things in mind?
Well, I have an MOU in place with the Commissioner, which means that I receive various documents, including minutes and meeting papers of operational and corporate governance meetings. So I have some visibility over that work. And if something arises that I'm either concerned, interested in, or want to make an observation about, I do. I not infrequently write to the Commissioner with observations or comments or the like, or seeking further information about those matters.
Are they properly responded? Are they promptly responded to?
Yes, they respond to me, and as I think the CEO said before Senate estimates recently, they have made various changes as a result of observations I've made arising from complaint handling, or indeed responding to matters that arise in those meetings. So there have been various changes to the triage process that they've made as a result of comments I've made, for which I am grateful and I think have improved the process.
Yep. And do you have any thoughts about the appropriateness and or ambition of their KPIs, considering some of the outcomes that they report on?
Well, it's early days for their KPIs in terms of reporting and investigations because, as we keep hearing, it's 2.5 years in. The KPIs of 85% in relation to the 90 days, to me, seem quite reasonable. But I think that if you were to compare them to other like organisations, that would give you a better idea as to their reasonableness or not. But nothing has jumped out at me as being unreasonable, bearing in mind we don't know whether the KPIs for investigations and the like will be met because there haven't been enough of them to comment in a realistic way.
Yeah. I note in your report you didn't conduct an audit in this time period, but you did review the Commonwealth Ombudsman's report. Can you share with the committee any future plans that you have, or in terms of an audit function yourself, or what the areas of focus might be, if you've turned your mind to that yet?
Look, I think it's fair to say that the combination of robo-debt and defence at the moment has kept me busy enough not to need to find an audit to keep me occupied. But having said that, look, the sort of matters I would think of auditing at some appropriate time, which I must say would be further down the track, is exercise of coercive powers in terms of compliance with law and policy, execution of search warrants. These are matters that I've done audits on before in the New South Wales. So those sort of matters, but you'd really want a few years under its belt before you did that to make it meaningful, because, as the Commission has said, things have changed and evolved quite significantly in the triage and assessment area, and no doubt in other areas over the last 2.5 years. So I'm not sure that an audit would be particularly revealing at this stage.
Mm-hmm. Okay. Thanks, Chair. Thank you.
Thank you, Senator. Mr Pike?
I've just got a couple of questions. Firstly, on you've mentioned resourcing, you've mentioned the recruitment and retainment. I'm just keen to get a general sense. Do you think that the NAC is adequately resourced? From
my understanding of their budget, and I'm a lawyer, not economist. They have underspent on each of the last 2 years, which would suggest to me that they are not under-resourced.
Okay. Do you think that the issues of recruitment and retainment that you've spoken about, were you surprised by those? Do you have any reflections on why that's the case? Is there an issue with the culture within NAC in these early days?
Well, I suppose it depends what you mean by culture. There certainly is an issue with retention in the triage and assessment area, and I think from other material I've read, perhaps in the legal area, there are vacancies. Why that might be, a number of reasons. The triage and assessment area is the front line, if you like, and presumably it's probably difficult work in that you're dealing with people who are upset before they come to you, and then perhaps even more upset when they don't get what they think they should get. So that may be the case. Look, the structure's a matter for them, and I think it's questions for them as to how they structure the triage and assessment and maybe the legal area to understand why they think there are issues. I really don't have sufficient visibility, and management consultancy is not my biggest skill to tell them what to do.
That's all right. We'll certainly ask some questions on that a bit later today to the Commission. I'd be keen to get your perspectives on the education and prevention side of things. What's been your perspective on their performance in that area to date? And compared to what you see, for instance, in New South Wales, what would what's been your advice, or what will be your advice moving forward on how they can improve that side of their operations?
Well, they list in their annual report all the work they've done in the area of corruption prevention and education and the like, and I think they have KPIs in respect of numbers of engagements and the like, so that's available from their annual report. As to what those events have achieved, it's a bit hard for me to say. They may well have performance indicators in mind, and perhaps they can tell you whether they've met those or not. It's an important area of work for all corruption agencies, is not just to investigate. So it's not just detecting and exposing, it's actually preventing and educating. So it's an important area of work to ask them about.
It's a hard one to measure the performance of, though, isn't it? Is there a way that you do that in New South Wales that will illuminate, your work at the federal level?
I think in New South Wales they use a number of measures. They've been doing it a long time, but they frequently have things like surveys afterwards to determine the engagement and the effect of what they do. I think they also look at it in terms of complaints from various areas. So if, for example, there's an area of endeavour which they think should be attracting more complaints, they will go out and talk up the work they do there. So that's a measure of whether or not that has any effect. So there are measures available in New South Wales, and I'm sure the Commonwealth has them. I'm not entirely sure how they measure as to their own performance. But their annual report, I'm sure, would deal with some of that material. But the bottom line is it's important work.
Absolutely. Thank you, Chair.
Thank you. Deputy Chair.
Thank you very much, Chair. Maybe just to pick up on Mr Pike's theme there, Inspector, in 2024-25 the Commission received a total of 107 mandatory referrals. I'm wondering if there is some correlation, I suppose, between mandatory referrals from Commonwealth departments and that issue of education around corruption. I'm curious because I'm wondering if that's consistent with the size and scope of the Commonwealth public sector and how that volume of mandatory referrals compares to what's received in New South Wales, for example.
My understanding is New South Wales receives a lot more mandatory referrals from public agencies, but it may well be that there is a test, if you like, of serious or systemic in the Commonwealth for people to make mandatory referrals. So that may reduce the number in the Commonwealth. I know that what the ICAC does is it looks at where those referrals are coming from and considers what it knows, from all of the work it's doing, including its corruption prevention, as I said before, where they should be coming from. And if there's relatively few mandatory referrals in a particular area, I know they target that area. And I think that in recent times has been quite successful in one area, and that's how the corruption prevention, if you like, as well as the exposure and detection, work together to generate more awareness in particular sectors.
To my mind, it could be a good indicator in terms of the work that needs to be done around prevention and education.
I think so.
Have you got a sense, or have you got any indication that the National Anti-Corruption Commission are looking at mandatory referrals as an indicator of the effectiveness of their prevention work?
I don't know, is the short answer. I don't know.
Can I just take us back to the delays, the timeframes around responses to referrals? And I draw your attention to an article that was published today in the Australian around fast-tracking referrals and expedited reviews. And again, with your eyes on the work that happens in Triage, have you received any complaints in regard to requests for a fast-tracking of a particular referral? And I note that the two instances reported today, one was in regard to a complaint made towards the AFP, and another one was in regard to Operation Kingscliff. The Operation Kingscliff received an expedited review, but the other matter did not. Did you receive any complaints around this issue?
Well, I'm at a disadvantage, and I didn't get past the ABC this morning, so I haven't read the Australian article. And I heard the questions that Senator Shoebridge asked in respect to the Kingscliff matter and the use of expedition. It's not a concept I'm familiar with from receiving complaints or reading material from that area. So I don't know whether expedition has a, as a term of art or not. I know that they have something, or had, I think they still have something called a complex pathway, and so matters that fit some criteria head down that path. And I know they've made quite a few changes in terms of directing traffic, if you like. I'm not sure about the expedition with the Home Affairs matter. I don't know what that means. And I don't know about the AFP matter, but clearly it's always matters of judgment. You get a lot of material in, you've got to make a call as to which you do first, in which order, who does what. And, I say it's not rocket science without meaning to be rude, but agencies do this all the time. So they have a system in place, I'm sure, that you can interrogate them about what seems to be working or not working in that. But it's imperative that there is a good system in place to triage. That's why it's called triage.
In your experience with the New South Wales ICAC, is there such a system whereby someone may ask for fast tracking? Is that part of their triage system? Is there a box that you can tick or an explanatory area that could indicate why your particular referral requires expedition above all others?
Look, I don't get many complaints at all in ICAC about things taking too long. The complaints I get in the ICAC are similar to here in the sense of they didn't investigate my complaint referral and I wish they had. That's the bulk of it, rather than timeframes. I think it's a different system in place, but it's essentially you need to have a system whereby you make judgment calls about what goes where and who does it and when. And I'm sure they have one in place. I come back to, because to be fair to the NAC, they meet their 95%. So clearly something is working, or 85%, I beg your pardon, 85%. Something is working for those cases to be done within the 90 days. But then there are the cases that you get and I get which are significantly delayed. I don't know how that fits together.
That's the more interesting part, actually, isn't it?
Yes, it is.
And just back to an earlier part of your evidence, Inspector, when we were discussing around the disclosures by the Commissioner of his consultancy with the IGADF, and it's been indicated that he had disclosed that work with the former Attorney-General. Who else should have been made aware of that outside of the Attorney-General?
Well, I don't know who he told. From the CEO's evidence, he didn't know. I don't know, didn't know. I don't know whether he told anyone else because it hasn't come out. So he may have told the deputies, he may not have. I don't know whether he told the current Attorney-General. So I don't know who he told. To my mind, and coming back to basic principles about conflicts of interest, it's identification, disclosure and management. So whether or not, assuming it was just the then Attorney-General, that was sufficient or not, I don't know. But I think this committee can obviously ask him who he told and why he made the decision to tell people or not tell people.
In terms of good process, transparency and accountability and ultimately public trust, do you think on significant matters of conflicts that commissioners in fact should notify this committee, the inspector, anyone else?
It depends at what stage the conflict arises. Largely, the discussion has been about assessment, and the approach the Commission takes is that it records in the minutes of its meetings whether or not somebody has a conflict in respect of a matter that's being discussed at that meeting. So there is an immediacy to that. In terms of broader conflicts, that's the purpose of the annual disclosure and also the original disclosure that the Commissioner made to the then Attorney-General. So that's the system that has that's in place as I understand it now. So the question is whether there's something in between telling the Attorney-General and on individual matters, or I suppose whether or not there's any public process for the general disclosure to the Attorney-General being public. I mean, I could be wrong here, but I certainly made that letter public in Robodebt inquiry. I don't know whether it was public before. I don't know whether it should be. I don't know whether this committee receives that routinely or not. This has all become an issue relatively recently, and they're legitimate matters to discuss and think about as to whether they should be more public or given to different people on different occasions. But I'm repeating myself, but there's the declaration in minutes and then there's the declaration to the attorney, and is there or should there be anything in between?
What would your view be? Would it be your view that the declaration to the attorney is a public document?
Well, I think it was obtained through FOI with redaction, so that suggests that there's no problem with it being public with appropriate redactions for personal information. In terms of the IGADF, I would have expected that it would be known within the senior executive of the Commission.
Thank you.
Senator Shoebridge.
Thanks. One of the reasons there are annual returns and reportings of conflicts of interest is so that there can be public confidence that conflicts of interests are being dealt with by an organisation, and that public confidence is part of the declaration process, isn't it?
It is.
There's no point locking yourself in a broom closet and declaring your conflicts of interest and then stepping out and continuing doing your work. That wouldn't satisfy the need, would it?
Well, and that is not the system. That's right.
again, produced under FOI, not produced publicly by the NAC. There've been a series of letters from Commissioner Brereton identifying his declarations of material personal interests. There was one on the 14th of October 2024, another one in near identical terms on the 16th of September 2025, and then a rapid follow-up on the 22nd of October 2025 to the attorney. Have you seen those declarations?
I have.
There was a significant change between the 16th September 2025 one and the 22nd of October 2025 one in relation to the IGADF. Can you describe that change?
Well, as I understand it, and I don't have it in front of me, that in the October 2025, the Commissioner referred to the ongoing role in providing advice to the IGADF, and that was not provided in terms in the previous declarations.
Yeah, and indeed, I've got the benefit of the 22nd of October letter in front of me, and the addition that I read in that one was these words starting at the bottom of page 1, in reference to the Inspector General of the ADF, IGADF, to whom I continue from time to time on an informal and voluntary basis to provide advice and respond to requests for information relating to the Afghanistan Inquiry Report, in accordance with the arrangements described in the then Attorney General's letter to me of 30 March 2023. To date, and in accordance with the arrangements described in your predecessor's letter of 30 March 2023, I have taken the approach that should a matter potentially affecting any Defence or ADF unit or individual with whom I have or have been associated in a way that might reasonably be perceived to create a conflict come before the Commission, I do not participate in decision-making and I delegate it to a Deputy Commissioner. I think, and then there's a reference to henceforth not undertaking ADF referrals. I think that's the difference, isn't it?
Yes.
That additional. Have you seen the Attorney General's letter of the 30th of March 2023?
I have, and as to the source, I'm not entirely sure. I suspect it was through an FOI application that was made, perhaps to Defence, that was subsequently published on Defence website. I've certainly seen it, and I think that's the source of the material to me.
Do you have a copy of it at all?
Probably.
Yep. If you do, could you provide it to the
Certainly.
committee? Do you know how?
Just in terms of scope, we are on 24-25 annual report. Where are we going back to at the moment?
This is a letter that the Commissioner Brereton is relying upon in communication of the 22nd of October 2025.
Okay, thank you.
Look, I suspect it's on the Department of Defence website, but I could be wrong.
Yeah. Do you know, can you recall the terms in which the Attorney General apparently referred to the ongoing work in the IGADF?
Well, it's written in the letter.
Yeah. I haven't got the letter before me here. That's the difficulty.
Look, I couldn't quote verbatim. It referred to what sticks in my mind is it says that that any new or formal work shouldn't be undertaken, but I can't remember the language it referred to, the work that was being undertaken. I can't remember the language, but I certainly do have a copy.
Yeah, I'm sorry, Inspector.
Somewhere.
I'm not trying to make this an inappropriate memory test.
No.
And you're probably right. The best way of addressing this is to look at the letter rather than do an imperfect memory test of you here. But other than that reference in the Attorney General's letter of the 30th of March 2023, have you had provided to you any other documentation that identifies Commissioner Brereton saying to either his team, yourself, the Parliamentary Committee, the public at large, that he was continuing to do work with the IGADF while having the role as a Commissioner?
Subject to reading the 400-odd pages that I received in the last few days, no.
Yeah. And indeed, the extent of work that the Commissioner has been doing for the IGADF has only slowly become apparent in a series of partial disclosures, as I read it, to parliamentary committees on request.
Yeah, and I've read that material as well.
And in your experience as long-standing experience as Inspector of the ICAC, and now your experience for some 2 years with the NAC, is that how you would expect a conflict of interest declaration to happen, for it to trickle out in parliamentary committees? Or going back to that document that the NAC has, how should they have dealt with it?
Well, I go back to my answer to Dr Haynes's question. To my way of thinking, the ongoing advice to the IGADF should have been disclosed to at least the senior executive of the Commission. That's my point of view. That's my view, if you like.
Yeah, but obviously you've got a bunch more documents you're going and which may cut across this.
Well, it may, although the CEO's evidence was, at least in this respect, unqualified, that he didn't know about it.
I recall, yes. Thanks, Chair.
Thank you. There being no further questions, that concludes today's hearing with the Inspector. Thank you for your evidence today.
Thank you.
The committee will now adjourn and will return at 11:15 with officials from the National Anti-Corruption Commission. I declare open this public hearing of the Parliamentary Joint Committee on the National Anti-Corruption Commission for its examination of the National Anti-Corruption Commission Annual Report 2024-25. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to any Aboriginal and Torres Strait Islander people with us today. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. Before we begin, a brief word on the role of the committee. The functions of the committee are set out in Section 177 of the National Anti-Corruption Act 2022. These include examining the annual reports of the Commission and the Inspector. The committee also has a role in relation to reviewing the budget and finances of the Commission. This hearing is also an opportunity for the committee to undertake more general functions under Section 177, including monitoring the performance by the Commissioner and Inspector of their functions and examining trends and changes in corruption among those who are subject to the Act. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. It's also a contempt to give false or misleading evidence. The committee generally prefers evidence to be given in public, but witnesses do have the right to request to be heard in a private session. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. The committee has set 20 January 2026 as the date for responses to any questions that are taken on notice. I now welcome the Honourable Paul Brereton, Commissioner of the National Anti-Corruption Commission, and senior officials of the NAC. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you each please state your full name and the capacity in which you appear today?
Paul Brereton, National Anti-Corruption Commission. Thanks, Chair.
Philip Reid, CEO.
George Philip Devet, General Manager, Enabling Services.
Rebecca Omar, General Manager, Legal. Nicole Rose, Deputy Commissioner.
And online?
Kylie Kilgour, Deputy Commissioner.
Ben Gauntlet, Deputy Commissioner.
Thank you. Commissioner, I now invite you to make a short opening statement, and after that we'll proceed to members' questions.
Thank you very much, Chair, Deputy Chair, members of the committee. First, I'd like to take the opportunity to refer briefly to some of the highlights of our second annual report. The Commission has grown from 154 staff when we began to 231. We now operate out of 4 offices nationwide, 3 of which have been constructed and occupied since we began. In the 29 months to the 30th of November, we'd received a total of 6,669 referrals, of which we had completed assessment of about 86%. By the 30th of June 2025, we'd commenced a total of 40 corruption investigations. 9 had been finalised on the basis that corrupt conduct would not be established. 30 remained on foot. During the reporting period, in matters that we initiated after our establishment, we published our first investigation report in Operation Kingscliff, and we secured our first conviction in Operation Pelican. Operation Kingscliff concerned a paradigm case of nepotism in recruitment in the public service. Operation Pelican concerned an official seeking a secret commission for facilitating the award of a multi-million-dollar contract. During that same reporting period, we also secured 5 convictions and published 3 further investigation reports as a result of investigations that were commenced by the Australian Commission for Law Enforcement Integrity, but which we took over and continued through to completion. Reports are currently in preparation in 2 Commission matters and 2 Actley matters, and 4 other matters are currently before the courts. In 3 matters, we made public disclosures that no corruption issue arose to clear the air after there had been public reporting that there had been a referral to the Commission. These included a public statement in relation to the settlement between Ms Brittany Higgins and the Commonwealth, about which there had been significant public speculation that there might have been corrupt conduct. We conducted an extensive preliminary investigation and found that no corruption issue within our jurisdiction arose. The ability to dispel suggestions that there's been corrupt conduct is as important as exposing it where it exists. During the year, we obtained 22 search warrants from courts, 9 telephone intercept warrants and 6 surveillance device warrants. We issued 184 notices to produce documents or information, and we examined 24 witnesses in private hearings in 6 investigations. Our strategic corruption priorities remained corruption in senior executive decision-making, corruption involving contractors and consultants, corruption affecting vulnerable people, corruption affecting the environment, corruption at the border, and corruption in complex procurement. We also negotiated 2 important memoranda of understanding, one with the Australian Federal Police that provides a framework and arrangements for deconfliction, joint investigations, information sharing and access to technical capabilities, and an MOU with the Parliament in relation to parliamentary privilege. This establishes agreed processes for the exercise of our powers in circumstances where issues of parliamentary privilege could arise, in order to ensure that parliamentary privilege is respected, while permissible action by the Commission to detect and investigate corrupt conduct is not inhibited. And I would like to note that we have had excellent cooperation and assistance from the clerks of both houses in implementing the mechanisms under that MOU. We've also designed and delivered in partnership with Tasmania Police an authorised officer training course, which 90 of our staff have now completed to gain the skills and knowledge to perform the functions of an authorised officer under our legislation. And we're leading the design of a pilot course to train investigators in anti-corruption and integrity investigations in conjunction with the AFP and state and territory anti-corruption agencies. In our prevention and education function, we conducted 138 engagements, reaching public servants across all levels and agencies and parliamentarians, in addition to members of the private sector and civil society. This has delivered important anti-corruption messaging, contributing to the integrity conversations that are occurring across the Commonwealth sector and the Australian community. We also made 9 submissions to a range of consultations and reviews of corruption and integrity policy. Ahead of the federal election, we published an open letter to election participants about corruption risks and vulnerabilities in the context of an election. We've also published and distributed guidance for parliamentarians and their staff, guidance on conflicts of interest, and guidance for government business enterprises. We conducted the inaugural Commonwealth Integrity Survey, receiving and analysing responses from nearly 60,000 officials across 170 agencies. The outcomes and evidence from that are an important guide for our ongoing corruption prevention and education, as well as investigatory activities. 2 years is a short time in the life of a national institution, but I think the consciousness of integrity is an issue across the Commonwealth public sector, and Australia's enhanced standing on Transparency International's Corruption Perception Index, while by no means attributable only to the Commission, reflect our establishment, our existence and our activities. I expect that when we enter our next phase, or as we enter our next phase, complex investigations will reach completion and our operational achievements will become more visible. Secondly, I want to address another issue. For the whole of my adult life, including when I was a judge, I have combined my civilian career with service in the ADF reserves. Governments of all colours have encouraged and supported reserve service since Federation, including now through the Defence Reserve Service Protection Act and various public sector leave policies which provide paid defence leave for public servants. Its special nature is even reflected in Section 44 of the Constitution, which contains a specific exception that permits parliamentarians to continue in defence part-time service and to be remunerated for it. My association with the Defence Force as a Defence Reservist for over 45 years, and my work as an Assistant Inspector General on the IGADF Afghanistan inquiry, was a matter of public record and very well known before my appointment as Commissioner. That long-standing connection meant that regardless of whether I maintained any ongoing association with Defence, there would necessarily be occasions where potential conflicts would arise that it would be necessary to manage. That would have remained the case regardless of whether I terminated any further association with the ADF from my appointment as a Commissioner. Potential conflicts would still have arisen from those past associations. Until my recent announcement that to avoid the distraction this has become, I would not participate in any defence referrals, I've managed potential conflicts in relation to defence referrals, just as I informed the then attorney before my appointment, and as I've repeated in my subsequent annual declarations of material interests. When a referral to the Commission has potentially affected any ADF unit or individual with whom I am or have been associated in a way that might reasonably be perceived to create a conflict, I've delegated it to a Deputy Commissioner. In particular, I have not participated in consideration of any matter involving the interests of the IGADF. Prior to my appointment as Commissioner, I informed the then Attorney-General and he acknowledged that I intended to retain my commission in the ADF Reserves, to maintain my honorary appointments as Colonel Commandant of the Royal New South Wales Regiment and the University of New South Wales Regiment, and to continue on an informal basis to provide advice to and respond to requests for information from the Office of the IGADF in relation to ongoing work related to the implementation of the Afghanistan Inquiry Report, the importance of which the then Attorney also acknowledged. I've unique knowledge of the Afghanistan inquiry which cannot be sourced elsewhere. Since it was completed in 2020 and before my appointment as Commissioner, that required ongoing consultation with me from time to time, and when my appointment as Commissioner was under consideration, I anticipated it would continue to do so. It would be a waste of time and resources and utterly unreasonable if the IGADF could not, in furtherance of implementing my recommendations, seek and obtain information from me. The only persons who would benefit if I did not do that are those who don't want the recommendations to be implemented or who don't want the Office of the Special Investigator, who is responsible for the criminal investigations that I recommended be instituted, to be able to do their job. And so in that regard, I have, on about 22 occasions over the last 29 months, on a voluntary and completely unremunerated basis, responded to requests from the IGADF for advice and information relevant to the implementation of the Afghanistan Inquiry Report. As best I can estimate, and it is an estimate, this has involved about 24 hours of my time over 29 months. Most of it outside ordinary business hours, and the approximately 8 hours that were in ordinary business hours is offset many, many times over by the time outside ordinary business hours that I spend on my work as Commissioner, which has been my overwhelming focus since the 1st of June 2023, when I commenced as Commissioner Designate. And finally, I would like to record publicly my gratitude to all the Commission staff for their hard work and dedication. For some of them, it is really trying and difficult work, particularly those at the coalface in triage and intake, and also to my fellow statutory office holders for their support and wise counsel and their contributions to the leadership and guidance of the Commission. Thanks, Chair.
Thank you, Commissioner. I'll start on where you took us to in that statement on matters relating to defence. We did just hear from the Inspector in her evidence that she has had 90 complaints in this financial year relating to people concerned about potential conflicts of interest that you hold in relation to defence matters that have been referred to the NAC. I said to her when she gave us that figure that what concerns me around that is that it perhaps suggests a lack of public confidence in the NAC and the independence of the institution. As you mentioned in your opening statement, it's a new institution, and I'm sure you're trying to establish it as one that has a very strong public perception as how it undertakes its role. Is that a concern that you share in terms of public perception about conflicts of interest there?
Of course it's a concern I share, and that's one of the reasons why I've taken the step that I have of stepping away from defence matters completely. It's been a really difficult decision, Chair, because I actually think I add to those defence matters because I know not so much where the skeletons are, but I know how to go and look around the place and to find things in defence. I know the lines of inquiry to follow. So stepping us away from that has been a difficult, very difficult decision for me. I would have thought that the Afghanistan inquiry demonstrated pretty clearly that I was able to be independent, robust, even fierce in pursuing misconduct in defence. But because of the risk of that public perception, I have made what for me has been a very difficult and emotional decision to step away from that. In terms of the number of complaints the inspector has received, I would though mention that one particular fringe website which published some information concerning the procural of counsel assisting had a line on there, send your complaint to the inspector, it only takes a minute, and the more complaints you send in, the harder it is for the inspector to ignore them. So I do think it is very easy to put too much weight on the number of complaints that have been made.
It is one of the measurements, though, that the committee, I suppose, has to look at how the NAC is being considered, and I presume the inspector also has to take complaints seriously.
The complaints have... I would just ask that they be looked at in the context of, first of all, where they are being generated from or how they are being generated, and partly, whenever you're looking at a complaint, it's a good question to ask to whose benefit, who, as I think it was Cato said, cui bono, for whom is the benefit in this?
So that the committee is clear on the scope of the decision you've made to step away from matters relating to defence, can you define for us what does that mean? That you have, when a complaint comes in, do you see the complaint? Is there any stage of the process where you have oversight or visibility of that complaint?
There is no stage at which I would have oversight of it. It is possible that in some cases I would have visibility of it because normally conflicts are recognised when they come to the senior assessment panel for decision. That's when you look at the papers, you say, "Whoop, I have something to do with this," and then you declare a conflict and get out of it. So that's the only context in which I would have visibility.
Is there...
I would not have ongoing visibility after that point.
So after that point you wouldn't see that matter again, but you would understand that the matter had come in?
Yes.
Have you given any consideration to setting up a separate line altogether for defence complaints?
We've given some consideration to it and decided it would complicate matters too much at this stage to have a separate system for dealing just with defence complaints. There are other, all of the statutory office holders have conflicts. They've all been associated with previous organisations, and if we set up separate systems for each of the for complaints from each of the organisations which they've had a prior affiliation, we'd be setting up multiple or so many different systems that we think the simplest system is that all these complaints are dealt with the same. As soon as it is obvious that it's a defence one, I get out.
Okay. And then in terms of your ongoing role with the IGADF. Thank you for the additional information that you provided the committee. Would you intend or propose to continue to update the committee about when you have contact with IGADF, and if so, how would you propose to do so?
I would frankly be very reluctant to do that, because there are people out there who would love to know each occasion that I consult with IGADF, in order that that can be linked up with other events and can be used to undermine activities that are taking place, including by the Office of the Special Investigator.
So you're saying could we expect a regular annual update, or just it's too difficult to do altogether?
I'm happy to update you annually, but I think it's, if you look at the pattern over the last 3 years, you can see that it's decreasing, and it's certainly decreased even further from before that. And I'd be happy to say annually that I've consulted with the IGADF on X occasions, and it took approximately Y hours of my time.
Thank you. Just a couple more questions from me before I go to committee members. Turning to the timeliness of investigations and communications to those who have referred matters to the committee, I understand you're meeting your KPIs for timeliness. I'm interested in hearing more about how you triage incoming complaints. The inspector in her evidence said that she is receiving complaints from people who are waiting a long time for communications from the NAC about how their complaint is being handled. So can you talk us through the process of when a complaint comes in, how it's triaged, and when complainants should expect to hear from the Commission about the progress of that investigation or non-investigation, as the case may be?
Thanks very much for that question, Chair, and the opportunity to explain that. So, first, I want to make a little bit of a confession about the KPI. We are meeting our KPI, and on the basis on which the corporate plan stated it would be measured, and on the way it is set out in the annual report as being measured. That said, we go on in the annual report to make clear that that doesn't tell the whole story, because it counts complaints that we have finalised and the proportion of them that were finalised within the 90-day period. The complaints that have not yet been finalised don't get picked up until the next cycle. So there's a little... we're very frank that the KPI does not tell the whole story. But I do think it is fair to say that obviously the cases that the inspector hears about are amongst the 15%, not amongst the 85%. So the way the triage system works is a referral is received, typically in most cases by web form, occasionally by phone, and very occasionally by hard copy mail. The first stage in the process is the triage process, and to date that has essentially involved a triage officer who is at the APS 4 or 5 level, identifying whether it's within jurisdiction, so that's the first part of the triage, whether it appears on its face to raise a corruption issue, and now more recently we're introducing an additional question at the triage level, which is whether there is any real prospect that it's a matter that the Commission would investigate. If a matter does not pass triage, then on lodging a web form, and we introduced the automatic acknowledgement more than a year ago now, but an automatic acknowledgement goes to a web form which includes includes a statement that if we need more information from you, we'll get in touch with you, and that we aim to assess referrals within 90 days. a little bit all over the place with this, but we have recently, partly in response to feedback through complaints that have gone to the inspector, but very largely from our own work as well, we have redesigned that automatic acknowledgement letter, and there is now a new form of that automatic acknowledgement being provided in response to web forms. Most of the actual triage process that I've described happens within 30 days. So that Tier 1 triage is generally, not always, but generally decided within 30 days. If a matter passes triage, it then gets escalated to Tier 2 assessment, where an assessing officer looks in much more detail at the matter, will conduct open search resource, will sometimes request further information from the referrer, and will also sometimes request further information from agencies. Unless we go to a preliminary investigation, compulsory production powers aren't available at that stage, but there's still an opportunity to gain a fair bit further information. The assessing officer then makes a recommendation as to whether it crosses the potential serious or systemic threshold and whether it's a matter that we would investigate or not investigate for other reasons. If the decision at that level is that we should take no further action, that can be signed off under the legislation and under our delegations by a director or by the general manager. If the recommendation is to take some action, that comes to our senior assessment panel. In addition, the matters that are no further action decisions under delegation are brought to our senior assessment panel for noting, simply so that we can monitor the lower level decision making. And sometimes we'll look at something at which there's been a no further action decision and decide, no, that does need a further look, and come to a different view. The referrer will be told if at any stage, or provided they've provided a point of contact, will be told at any stage when we decide to take no further action on a matter. There's a great deal of difficulty in saying to a referrer, this matter has proceeded to investigation, because we don't want to give referrers confidentiality directions that they can't talk about something, but at the same time we've had cases in which we have disclosed information to a referrer and that then ends up in the public domain. And it's frankly not in, or it's usually not in the interests of any investigation for the person under investigation to know that we've decided to commence an investigation. Now, that's one of the real difficulties in providing much information with referrers. But there are some cases, and there is, for example, the case reported in the Australian this morning, is one in which we have engaged extensively with the referrer during the period of that preliminary investigation. And I must say that I thought that we had an investigator working on that who developed quite a good rapport with the referrer, for whom I have an enormous amount of sympathy. We are currently looking at the ways in which we can improve contact with the referrers, and our General Manager Evaluation and her team are examining ways in which we can address that. We recognise that some referrers do seek out that contact, and we recognise that there's a need to address that, and we've got a project underway looking at that at the moment.
All right, thank you. Deputy Chair, I'll hand over to you.
Thank you, Chair. Thank you, Commissioner, and to all members of the Commission here today. Commissioner, I just wanted to circle back to your comments regarding the motivation of people who are complaining to the inspector in regard to the conflict of interest issue that you outlined in your opening statement. You would acknowledge that the general public have every right in a democracy to make a complaint to the Inspector General under our system.
Of course.
Yeah. I'm also conscious that in the Inspector's report on page 17, she noted that one of the complainants was in fact a employee of the National Anti-Corruption Commission, currently.
I think a former employee.
Yes.
Yes, and that employee made, I think, 9 complaints to the inspector about a raft of matters.
Including the conflict of interest, as I understand it from the inspector's report.
In respect of one matter, yes.
I think it's important just to highlight that while there may well be many complaints made for various purposes, that's a significant complainant, and that's, as I understand it, the inspector is looking further into that according to her report.
Well, as I understand it, that complainant made a raft of complaints in respect of which the inspector has accepted or put 2 aspects to us, has accepted our explanation in respect of one aspect, and that was an explanation that was provided in December of last year, 12 months ago, and the inspector's annual report told us for the first time that she hadn't decided about our response to the conflict of interest aspect.
Okay, thank you. Commissioner, I just want to go to the next statement on your recusal from ADF matters. The Commission's November 2025 monthly update was published on the 31st of October. Who drafted the monthly update?
All of it, or that particular part of it?
The whole thing.
The whole of it is drafted by our media team and then circulated for consultation amongst the statutory office holders. The part about the defence recusal is substantially my words.
Okay. Did you approve the publication? Is that your responsibility?
Both the CEO and I approve all publications.
Yep, okay. Under the heading Management of Defence Referrals, the update notes that Commissioner Brereton will recuse himself from all matters relating to defence and the ADF, and it concludes, and I quote, "The Commissioner is taking this step although it is unnecessary from the perspective of properly managing actual or apparent conflicts, solely in an endeavour to recentre the focus of our important operational and educational work." Was that the section that you drafted?
It's part of it, yes.
So is it the view of all of the Commission, in addition to yourself, that the recusal is unnecessary?
Well, I think you'll have to ask them that, but that's the view that I expressed to you on the morning of the 31st of October, and my view is that it is quite unnecessary from the perspective of the proper legal management of conflicts of interest for me to have nothing to do, or for me to recuse from a matter in which I do not have a relationship with an individual or a unit that could be perceived to affect the outcome. If no one known to me or associated with me is involved, there is no conflict and no need to recuse, and that's on the basis why I think the total recusal is, from the perspective of the proper management of conflicts, quite unnecessary.
Could I then ask the Deputy Commissioners if that is their view, that this is unnecessary? Maybe I could start with you, Ms Rose.
Yes, sure. That was a statement by the Commissioner, and that's his view, and I understand exactly the thought behind that, and that the conflicts are not real. However, I pushed quite strongly for recusal from all defence matters because I think that the perceptions of the conflicts have become an issue for the agency, and I think that that is absolutely the best course of action going forward.
So from what you're telling me, it sounds like you believe it is necessary.
I think the recusal from the defence matters in entirety is absolutely the right decision for the Commission. I don't believe that the Commissioner has real conflicts in many of those referrals. There's only a small percentage in which he knows the people involved, and he recuses himself from those quite early. It has shown over time, though, that people have a concern about the perception of his involvement, and I think that through the complaints, through yourselves, through the inspector, we've seen that concern by members that are involved in referrals about defence are certainly held more seriously than perhaps everyone had first realised, and I think that's why it's the appropriate course of action now that the Commissioner doesn't have anything to do with those referrals, and that we've gone back over the matters that he has previously involved himself in and looked at those.
Mr Gauntlet, perhaps I could ask you if you believe that this is actually unnecessary, as the statement indicates in the press release?
I believe the recusal was necessary given the status of the Commission at the time relative to the public opinion. I do think it's important to point out some legal framework issues in terms of the NAC Act, though, and how it operates. The Inspector General of the ADF is a separate Commonwealth agency under the Act to Defence. A corruption issue also fixates upon a public official and not on a Commonwealth agency. And with the Commonwealth contracting provisions, what that can mean is that the concept of involvement is a very dispersed one. So there are some legal nuances which sit around what is or is not defence, but I think in terms of the nature of the inquiries we were getting, etc., that it was the appropriate decision in the circumstances.
So from that, I'm hearing, please correct me, I don't wish to verbal you, that you believed it was necessary, even though the statement said, although it is unnecessary.
I thought it was necessary in the circumstances for reasons of the public stature of the NAC at the time relative to the public perception. But I could understand also the Commissioner's position about the need to focus upon particular interactions with public officials rather than Commonwealth agencies per se. And if you think of the defence portfolio, for instance, it includes such things as defence catering organisations, etc., which are simply things the Commissioner has never had any interaction with. So there are a lot of definitional issues in relation to it as well, Senator. So I think it's important to take quite a nuanced view of this issue.
Thanks, Mr Gauntlet. And Ms Kilgore, could you give me your view, please, in regard to this statement?
Yes, Dr Haynes. I agree. Well, how will I explain this? I think there are the issues about technically, legally, there may not be conflicts of interest at play, but out of an abundance of caution, I think this is the right approach for us to take in response to the community concern that's been raised with us. I think it shows that we are listening and we are trying to do our job in a way that builds public confidence.
Forgive me if I'm confused by this, but hearing this, I wonder why it was necessary for this media statement to actually have that phrase, although it is unnecessary. You may understand why that is confusing.
Just remind me, if you would, Dr Haynes, what does the rest of that sentence say?
The Commissioner is taking this step, although it is unnecessary from the perspective of properly managing actual or apparent conflicts, solely in an endeavour to recentre the focus on our important operational and educational work.
And I think that is all entirely consistent with what I said. It is unnecessary from the perspective of properly managing conflicts. It was the appropriate step to take to address public perception in the circumstances, and that's what I understand the deputies have said.
With respect, Commissioner, you did suggest that I ask the commissioners, and that's what I'm doing. So that's why I'm trying to get some clarity around this. Was there a discussion between the commissioners, with you perhaps, Mr Reid, as CEO, around this statement, how it would be worded and how indeed it might be perceived by the public when we see what is could be perceived as a very qualified statement on the Commissioner recusing himself now from all further ADF inquiries? Was there a formal discussion?
Dr Haynes, my apologies, but I was actually on leave, extended personal leave at the time.
Okay.
So I did not participate. It was not working at the time.
Thanks.
I don't think there was a discussion about the media statement. There was a discussion about the statement made in identical terms to you, the Chair, and other members of this committee that morning.
Okay. Thanks, Commissioner.
Because that statement was circulated and consulted on before it was made.
So, if recusal is unnecessary for the management of actual or apparent conflicts, it just, of course, leaves me with the question, then ultimately, why did you take this step? And the step, as you've explained to us, was around public perception and getting on with operational and educational work. That's correct, isn't it?
Exactly.
Yep. How many referrals have subsequently been allocated to Deputy Commissioners as a result of this decision?
So, before, earlier this year, the figure was 6 from which I had recused. Up to October, there were a further 3. As a result of this, there are 8 further matters which have been allocated to Deputy Commissioners.
And if I could just finish that line of questioning, has any work subsequently from the Deputy Commissioners been reallocated to you?
That's not been necessary at this stage. I have more than enough to do as it is.
Thanks, Commissioner.
For example, when Dr Gauntlet was on leave, matters that he had, or some of those matters, were allocated to another deputy at the time. And there are a couple of matters which another deputy has a conflict in that I'm looking at. So, yes, there is toing and froing on that all the time.
Thank you.
Yes, Senator Shoebridge.
Oh, thanks, Chair. Thanks all for attending. Just to give the Deputy Commissioners the opportunity to respond to Commissioner Brereton's statement, that the statement that said the recusal was unnecessary was circulated to all of you and you all agreed with it, that the recusal was unnecessary. Is that true, Ms Rose?
I'm just trying to look for it. I can't see if it was circulated. Sometimes they are, sometimes they aren't. And I, Senator, stand by what I said earlier, is that I pushed very strongly for the full recusal from the Defence Matters and for the reasons I've explained. And I think the Commissioner has explained why that he has found that very difficult, that he has a different view, but he listened to us and I think understood absolutely that the public perception was having an impact on the way that we did our work. But as he has said, because in many of these there is no real conflict, that he has felt that it's unnecessary. And by that I'm saying in matters that have got entirely nothing to do with the defence parts of the defence portfolio, which, as you know, is extensive, that we've taken a very broad approach to the matters that he's recusing himself.
Sorry, so the Commission has just confirmed that he's been a member of the ADF for 45 years, continues to be a member of the ADF and continues to do work for the IGADF.
Yes.
Are you saying that that isn't a real conflict of interest when matters involving the ADF come before the NAC?
I think the defence portfolio, I think there are areas in the defence portfolio. I think there's canteens. I think there's, I would have to probably defer to the Commissioner. There's probably about 30 or 40 agencies within the defence portfolio, and certainly I don't think he has knowledge of all of those. But do I believe that there is a significant perceived conflict? Absolutely.
And the test for conflict includes perception?
Absolutely.
And so when you speak of real conflict, you mean you're not excluding that well-understood legal test, which includes perception?
Not at all.
Okay. Did the other Deputy Commissioners, did you have that statement circulated, and did you agree with it, as Commissioner Brereton said, including the use of the phrase unnecessary? Deputy Commissioner Kilgore?
Senator Shoebridge, I would have to go back and check my records, because sitting here today, I really don't know. I'm sorry. That's the best evidence I can give you, but I'm happy to take that on notice and go and check.
All right. Deputy Commissioner Gauntlet?
I was on leave on the 31st of October, Senator.
And it wasn't?
So I simply don't.
All right. Commissioner, I'm having trouble understanding the question you asked we pose, which was who benefits from making complaints about you to the inspector regarding actual or perceived conflicts of interest with defence. What did you mean to whose benefit?
My question is who benefits from me not doing work from the IGADF?
Well, what do you mean?
As I refer you to my opening statement in which I made that quite clear.
Sorry, are you suggesting that the complaints that have come to the inspector are somehow being choreographed to undermine the work of the Office of the Special Investigator? And if so, on what basis do you make that fairly extraordinary assertion?
I'm not making an extraordinary assertion. I am simply suggesting that there are those who have an interest in me not being able to assist the IGADF.
And you think that's the cohort of people who have made complaints to the inspector about your conflicts of interest?
I don't know whether that's all of them, but I would not be surprised if that the people who would not want me to assist the IGADF.
Well, Commissioner, do you have evidence? Have you seen names? Have you seen indications that suggest that this is some sort of coordinated effort to tear you down from the IGADF? Because it's a pretty extraordinary response to say. Do you have evidence of that effect?
Senator, let me put it this way. All I raised was that, as I said in my opening statement, the only people who will benefit if I do not do this work are those who do not want my recommendations to be implemented.
Well, how on earth can you make that assumption? I'll withdraw that. Have you seen the names of the people who have made the complaints?
No.
Well, I think I'll leave it there. You said, Commissioner Brereton, that people saw your work in the Afghan inquiry as being fierce and independent. Do you remember that?
I said I thought that the Afghan report demonstrated that. I don't think I said people see it. I said I thought the Afghan report would have demonstrated that.
You understand that there is very real concerns about a particular conclusion that you put in your Afghanistan report, that senior commanders should not be held accountable for the murders of 39 Afghans.
I did not say that.
Well, I'll quote from the oversight panel and tell me if you think the oversight panel is wrong. The panel did not agree with the Brereton inquiry's view that some accountability and responsibility could not fall on the most senior officers, and it suggested that issue should be the subject of further consideration. Do you remember reading that?
I think that misstates what was said in my report. I don't have my report with me at the moment, and I haven't looked at it for a little while. But
Senator Sheebridge, I will just note again, we're not inquiring into that particular investigation. We're looking at the NAC annual report.
I'm simply responding to the Commissioner's assertion that people would view his work in that inquiry as evidence of fierce independence. And I'd put it to you, Commissioner Brereton, that at best, it is a very mixed reception that your report had, given no recommendations were made in relation to senior leadership.
Well, I don't know what sense you have of the community sense about it, and it's probably no better or no worse than mine.
Mr Reid, can you tell the committee when you first found out that Commissioner Brereton was continuing to work for the IGADF?
So that's on the record from my testimony that I gave to the Estimates, Legal and Constitutional Affairs Committee on the 7th. I'm happy to go back and read that back in to the Hansard if that's what you want.
This is a different. This is a different committee
I'm happy
with
to
a
go
different
back
set
to
of
Hansard
responsibilities.
and read it in if that would assist, so that there's no question that what I have said here may be different to what I said there, which has been an assertion you've made previously in relation to my testimony.
Mr Reid, I'm asking you to assist this committee, which is the NAC Oversight Committee, and give this committee evidence about when you first heard and the circumstances in which you discovered that Commissioner Brereton was continuing to work for the IGADF. And I'd ask you to answer the question to this Oversight Committee.
So I was aware of the fact that the Commissioner had been involved with the IGADF because that was part of the declarations of interests. I was aware that he was going to recuse himself from any matter relating to the IGADF that came to the Commission. What I was unaware of was the terms of the two-year extensions, and I became aware of that around the time of the media report, which I think was in the lead up to the 7th of October estimates hearing.
All right. So you say you weren't aware of the terms, the extension terms in those two requests, but I asked you about your awareness of the Commissioners continuing to work for the IGADF. So could you answer that?
Well, that was where it became clear, and you'll recall that there had been an FOI that yielded those two extensions that then became public as a result of media commentary by the ABC. And in those, it was quite clear that the reasons for the extension was that he would be able to undertake the provision of advice to the IGADF in relation to the inquiry that he had undertaken.
And so what did you then do to become aware of the actual circumstances?
Well, prior, as you may be aware, there was a very short time between when that story was published by the ABC and the 7th of October estimates. And in that time, the Commissioner and I had discussed that advice provision. And what I said on the 7th of October was, in effect, verbatim what the Commissioner had told me.
Which was it was infrequent and had not occurred during the work hours of the Commission.
That's correct.
Commissioner Brereton, why had you not told your Chief Executive Officer about your continuing work with the IGADF, and why, when he asked you about it, did you give him a version of events that he since had to correct on multiple occasions?
Well, I think the premise of your question is wrong. I do not believe he has had to correct it on multiple occasions. I think he has made one correction. But let me return to the first part of your question. Each of my declarations of material interest each year referred to my ongoing affiliation with the Royal New South Wales Regiment, the University of New South Wales Regiment and the Office of the Inspector General. Those declarations of material interest were provided to all the statutory office holders, including the CEO. I disclosed my ongoing affiliation to all of the statutory office holders in that document. I did not consider it necessary to go any further into the detail of the IGADF work, which was informal and confidential. And very infrequent, and as I said earlier today, represents about 24 hours in 29 months.
So was it because you thought it was secret, or was it because you thought it wasn't material?
Both. The fact that I had an ongoing affiliation was disclosed. The fact that I recused myself from IGADF matters was known. Beyond that, the particular work I was doing is immaterial because I was disclosing, because I was recusing from those matters anyway. And in addition to that, it was of a confidential nature.
Do you not understand, and I think maybe by reference to the NAC's own advice on this, that clear, public, transparent disclosures of actual or perceived conflicts of interest is the minimum expectation for the public sector?
Not if you recuse. If a judge recuses from a case, they do not have to disclose why they are recusing.
So you were making decisions to recuse yourself from matters, including decisions with all of your deputy commissioners in there, and you felt it was fine to not tell them why. Is that really your evidence?
They knew from the declaration of material interests that I had an ongoing affiliation with the IGADF, and they knew I was recusing from IGADF matters because of my past and ongoing association with IGADF.
None of them knew that you were continuing to work for the IGADF. None of them knew that that included work during the work hours of the NAC because you hadn't told them.
They knew that I had an ongoing affiliation with the IGADF, and that was all that was necessary to be known.
Well, you see, Commissioner Brereton, this isn't the first time your failure to deal with perceived conflicts of interest has put the NAC in hot water. We now know that about $1.2 million is being spent on the robo-debt external referral because of your failure to properly deal with an earlier perceived conflict of interest. Do you take any responsibility for that public expenditure of money?
Had we, from the outset, the part of the expenditure on Mr Nettle that is attributable to the way in which that conflict was dealt with was the initial part of his engagement when he was engaged to remake the decision. His ongoing engagement since then has been to support and advise the Deputy Commissioner who is conducting the matter, and in my view we would have incurred that expenditure or something similar to it anyway, because this was a referral from a Royal Commission presided over by a retired Supreme Court Chief Justice, and we would have wanted someone, if I wasn't going to do the inquiry, we would have wanted someone of that stature involved in any event.
Perhaps we might ask the Deputy Commissioner responsible for the robo-debt referral. Do you agree with the Commissioner's evidence that the ongoing involvement of Mr Nettle at considerable public expense is unrelated to the initial work that Commissioner...
I didn't say that. Chair, I object to the question. It misrepresents the evidence. I didn't say it was unrelated. I said we would probably have done it anyway.
Well, I'll ask you to rephrase that, Senator.
Deputy Commissioner, do you agree...
And sorry, before you go on, I'll just also note that I have members waiting, so this will need to be your last question.
Do you agree with the Commissioner's assertion that you would have engaged Mr Nettle or somebody similar to Mr Nettle regardless of the need to engage him to deal with the Commissioner's earlier failure to deal with a perceived conflict of interest?
Senator Shoebridge, so I'm the Deputy Commissioner, Kylie Kilgour, responsible for the robo-debt investigation. I do agree that given the referrals were made by the Honourable Catherine Holmes, I think she's an ACSC, that it is appropriate to have someone of Mr Nettle's standing and legal expertise on this investigation. It's a bit of a hypothetical question, I think, because I am where I am and the things that have happened. And so does that answer your question?
I think it does in part, and I know I'm pressing the Chair's patience here, but can you give an update on what on earth is happening with the robo-debt inquiry? Now, 6 years since it ended, nothing on the website, no information, and many people look at it. 6 years since robo-debt ended, and people are looking at it.
The robo-debt scheme ended.
Correct. I'll ask the question again. Can you give an update on what on earth is happening with the next review of the robo-debt? 6 years after robo-debt ended, lives have been lost, Royal Commission's been held, and there's nothing on the NAC website since July.
Again, I'd have to take that on notice because I think we have given some updates about the progress of the investigation, but it is an ongoing investigation. So obviously Mr Nettle made his decision in February. The investigation got stood up properly in, I think it was April by the time we commenced it. And it is underway, and I'm really limited in what I can say about ongoing investigations, and I think you understand the reasons why for that.
I don't understand. I'll be clear, I don't understand. I do not understand why you can't tell the victims of robo-debt. I don't understand.
The Senator didn't
permit the
witness to answer the question.
I've got 5 people talking at me at once. Can I have a moment? Sorry. I missed that question because Senator Henderson was talking to me at the same time, so I'm sorry I missed the question there. I think we've established that the Deputy Commissioner has taken that on notice. You have had a really good lengthy run. I'm going to pause your questions and we're going to move to Dr Garland. Thank you.
I just think the Deputy Commissioner had not quite finished.
Sorry, Deputy Commissioner, were you in the middle of giving an answer that you wanted to conclude there?
I just wanted to say, I would like to assure people that the investigation is underway. It is being taken extremely seriously. The team who are working on it, including myself, are working on it full time. And I hope that in the not too far away in 2026, I will be in a position to give the committee a further briefing and update. And I'm sorry, I can't say more today.
Thank you. Dr Garland.
And thank you to everyone for appearing today. My question really goes to public trust. I know my community is certainly, very invested in the NAC, and I think this really is an institution that goes to restoring faith in democracy at large. So I guess I've got a couple of questions that are probably best answered by the Commissioner in terms of, we've been given a range of information, for instance, around the recusal, which I think we've heard quite a bit about this morning, or this afternoon, in relation to defence matters. Now, initially we were told it was around 11, then at Senate estimates a different number was provided, and then this morning's opening statement said about 22 occasions. So that again, about an approximation, which, was a clarification we received previously. It's a bit imprecise. So I guess my question is to what will change in the future in order to make sure we get more accurate information in a timely fashion in terms of how, things could be a bit more proactive. And, obviously having faith in precision and accuracy is going to be very important for the public going forward with a new institution like the NAC. I think, it might seem like a minor point, but I don't think it is. I don't think we can be casual or nonchalant about, numbers and what the public should know. So I guess, on reflection, what could have improved, what could have been done better, and what lessons can we learn going forward to ensure that people have maximum trust in what is being reported to them from the NAC?
We place great importance, I would hope self-evidently, on the accuracy of the information we provide in public. For example, an enormous amount of research and cross-checking goes into the data that is in the annual report. As you will have seen from a letter I wrote, or the CEO and I both wrote to the committee on Monday, we identified errors in some of the data in the annual report, and getting to the bottom of that was an exercise that took members of our governance team about 2 weeks to work out what the discrepancies were after we'd first identified that there were a discrepancy, and then we wrote to the committee to provide what we currently believe to be the correct figures there. But extracting data is a manual exercise. So far as the number of occasions on which I provided advice to the IGADF are concerned, our first answer was based on what the IGADF had himself given in evidence in estimates, because I do not have in my, except in defence records, any record that helps me answer that. When I was able to access that, I was then able to identify each email in which I had provided advice or information and produce a count from there. And it was when I undertook that exercise personally of ascertaining how many occasions it had happened that I was able to update it and provide some sort of estimate of the time taken.
Well, thank you. I guess we'll clearly, look, maybe perhaps not clearly, but I would suggest, that it strikes me that maybe there should be a better way of keeping records of information being provided if it is, just an estimation in the future. It's not a huge volume, is it? 11 or 22, regardless of which number we choose here, which I think were the numbers provided. So it shouldn't be that difficult to keep track of that, I would suggest. But perhaps I'm wrong and there's a reason why it is a bit more difficult to keep track of that I'm not aware of. And I guess it is just, even as early as this morning, the numbers were about 22 rather than being a hard figure. And, again, I don't want to kind of harp on this particular example too much, but I guess it is just about, when there are those, I think, imprecise accounts being provided or clarifications being required, I guess for public confidence, what is being learned from this? And I accept, this is an institution in its infancy, effectively. How are we learning from that so that improvements can be made? Because, as I said, I know it's so important to the community that we have the NAC, and I just want to make sure that we learn as we go, and improvements are made, perhaps where they're reporting errors, and which I appreciate you've gone through some of, have been made so that people can have trust in the NAC.
Take on board completely the need for people to have trust in the NAC. The reason why about is used in this morning's statement is that there are various ways of counting those incidents that you can put a different construction on. For example, you will see that 2 separate instances are attributed to 4:16 p.m. on the same day. So I sent 2 emails responding to 2 different inquiries at the same time. We've counted that as 2 instances, but some would count it as 1. A bit later on, there's an instance where I provided, I think, 1 email very late one night. It might have been 10 or 11 p.m, and then another email at about 1 or 2 a.m. the following morning. Some would count that as 1 instance of advice in which 2 emails were sent. We've again counted it as 2, but that's why I'm reluctant to say it was absolutely 22, because there are different ways of counting, different permutations and combinations in counting this. What I think is the more relevant figure is that we're talking about something like 24 hours over 24 months, and we have spent more than that time in dealing with these issues over the last month. As to the other reason why this isn't, unlike the annual report figures, which are NAC records, these are not NAC records. This isn't the NAC doesn't keep count of what I do for the IGADF. That's kept in defence records, not NAC records, so that's not part of the NAC's record-keeping function.
Okay.
So far as the NAC's records are concerned, we have this year established an information management team. Our data and governance people and our information management team are working continually to improve our data tracking and our reporting. As I've said, we've had a glitch with the annual report this year. We want to avoid that next year, and we're doing a lot of work on that front to improve our information and data capture to ensure accuracy in that area.
Well, thank you for that, because yes, I was really quite interested in the sort of systems and processes that were being set up, and I think that goes some way to responding to that. In terms of those systems and processes too, I suppose I'm really interested in the way staffing exists at the NAC, and whether given the deep interest that the community has in bringing forward issues to the NAC, as they should feel comfortable doing, whether you think that the triage system is sufficient, what kinds of skills are within the team that works there, and whether there is any more capacity that needs to be built in there.
We are below our mandated average staff level. We are continually trying to recruit up to that level, and the issue is not in the resourcing of the staff level but in finding the people to do the work. I think this was touched on in some of the inspector's evidence, but the people at the front line doing the intake and triage work work in a very challenging psychological environment, particularly those on the phone lines, and they all get rotated through the phone lines in dealing with callers and providing advice and information and receiving referrals in that way. And so we have had I don't think it's the number, it's the turnover that is the issue, and we have a high turnover in that area because people get worn out. From day one, I've said at the Commission, we want people to have career pathways within the Commission. We would like you to progress from being an intake officer to a triage officer to an assessment officer, then maybe get an investigation qualification and move on to investigations. And that's a culture I really, really want to encourage. But we do find that particularly at intake and triage, and also to a significant extent in assessments, people burn out and we have high turnover. Now, the Inspector also made a comment that she thought this might be the case in the legal branch as well. I think the issue there is a bit different. The legal branch is superbly led. It has a fantastic morale and they provide really, really high quality work. However, the APS is the APS, and someone gets a job at an APS 6 level and an opportunity comes up at an EL1 level somewhere else and they'll go for it, and an opportunity comes up at an EL2 level somewhere else and then they'll go for that, and that's just the nature of the system within we work. And virtually all of our turnover in legal has been from people finding higher opportunities elsewhere and leaving for that purpose. And therefore we have to recruit again. We recruit a number, we make offers, some of them accept our offers, some of them accept offers elsewhere and don't come to us. But that's really a challenge in the recruiting area. I'm pretty strong on the view that it's not a resource issue, but it's a turnover issue and a recruiting issue in getting the people.
Well, thank you. And I think, I don't want to sort of speak on behalf of the other committee members here, but, we have difficult conversations all the time, and our staff do, with people on very sensitive matters that come to our offices for assistance, as do a number of other agencies in the government. So I think we're probably all quite aware of those challenges, just trying to understand what is being done.
Sorry, Dr Garland, we're really at time. I'm going to have to move on if that's all right. Thank you.
Sorry, I just want to understand what's being done to improve the situation for staff to stop the turnover. But I can put that on notice if that's more appropriate, Chair.
Maybe we can get that one on notice just in interest of time. Thank you, Dr Garland.
Well, Check, I'd really like to answer it now and not have one more question on notice to deal with. So one of the things we're doing to address that is exactly what I spoke about, creating these pathways for people to see an ongoing career within the Commission. The other is we don't leave people on the phones or in a particular job all the time, but rotate them through other jobs, and we give them opportunities to act up into the assessments area as well whenever we can. And providing that sort of variety is part of it, providing the career path is part of it, and looking after their welfare is a really important part of it. And we have a well-established employee assistance program and leaders who take a real interest in the welfare of their people.
And Chair, sorry, just if I could build on the Commissioner's
we might actually, I'll get you to expand further on notice. Thank you. We
so
do need
it's
to move
just
on.
To demonstrate.
Sorry, I'm just going to have to ask you to put any further information on that on notice. We need to move on. Senator Henderson.
Thank you very much, Chair. Good afternoon, Commissioner, and to you all. Section 177 of the National Anti-Corruption Commission Act sets out the functions of this committee, which include to monitor and review the performance by the Commissioner. I want to ask, in the context of the Commission's public statement made on the 12th of June this year about your determination in relation to the settlement between Ms Brittany Higgins and the Commonwealth, which involved a payment of some $2.4 million, this concerned the result of a preliminary assessment which made no finding of corruption. Now, you referenced this in your opening statement, and you say the Commission conducted an extensive preliminary investigation and found no corruption issue within its jurisdiction arose. Can I ask you, Commissioner, this infers that you are not ruling out corruption in another jurisdiction. Can I seek clarity whether you are just referring to your own jurisdiction, or are you suggesting that there's a possibility that corruption has occurred within another jurisdiction?
The our finding rules out or finds that there was no evidence of corrupt conduct by a person within our jurisdiction. That means a Commonwealth public official, and it specifically means the ministers of both the Coalition Government and the Labor Government before and after the May 22 election in the handling of Ms Higgins' claim and its eventual finalisation. I think it is really important to understand that this was handled in an entirely consistent manner by both governments before and after the May 2022 election, and the legal advice on which the ultimate settlement was based was provided, I think, in April 2022 and to the Coalition Government, and the same advice was maintained with immaterial changes after the May 22 election to the Labor Government.
Can I just go back to my question,
Certainly.
though? Can I seek clarity in relation to that statement? Are you suggesting that you are not ruling out corruption in the context of another jurisdiction?
Corrupt conduct means misuse of public power, position, office and the like. There is no misuse of public power by anyone that came to that I'm suggesting is open.
Okay.
What I will say is that false representations made to procure a settlement are not part of corruption.
Okay, I'll get to that. But since this time you made your preliminary statement and determination in June of this year, following that time there was the decision of Justice Tottle of the West Australian Supreme Court and further information now in the public domain about the conduct of the Commonwealth in relation both to that settlement and to subsequent proceedings which have been commenced by the former WA Senator Ms Reynolds and also Ms Fiona Brown. So given this new information which has come to light, have you reconsidered or have you considered reopening your investigation?
So we were aware, obviously, of the decision of Justice Lee in the Federal Court before we published our decision, and it being outstanding was one of the reasons why it took longer than it might otherwise for us to publish that decision. We didn't want to preempt it. The Justice Tottle's decision deals with a quite different issue from the question as to whether there was a corrupt conduct by a Commonwealth public official. The materials subsequently in the public domain concerning former Senator Reynolds' litigation in the Federal Court does touch on matters which we looked at, and nothing we have seen would cause us to change our mind about the conclusion we reached. But we made very clear in our statement on that what we were looking at was whether there was corrupt conduct, not whether there was negligence or a breach of duty, and that is at the heart of Senator Reynolds' claim.
Okay, Commissioner, just on that. So you've obviously considered matters subsequent to the public statement, the public disclosure that you made in June of this year, because you've obviously considered the decision of Justice Tottle, which was handed down in August. So can I seek clarification? Have you considered new factual matters following your public statement in June? And is there any basis to reconsider this matter? Because I just want to draw your attention to a report in The Australian published on the 12th of November, and this is entitled "Secret Documents Reveal Labor's Alleged Plot to Stitch Up Reynolds Over Higgins Payout," because what was disclosed in the discovery during...
I'm just going to pause for a moment. Can you? We are inquiring into the annual report.
Yes, I understand it, and I'm.
Can we just check on the relevance?
That's why I made it very clear in relation to the functions of this committee, and the processes involved in closing this particular inquiry. So further documents were discovered, which made it.
Sorry, can we go to? Are you trying to ask a process?
Yes, I'm asking a process question, Chair. So, Commissioner, further documents were discovered which made it clear the Commonwealth had new claims against Ms Reynolds, seeking an increased quantum proposed for settlement, none of which the Senator was aware of, the then Senator. And what I'm asking, in light of this damning further evidence which has come to light as recently as just weeks ago, is there not cause to reconsider the determination you made to finalise the preliminary investigation?
If Senator Reynolds wishes us to reconsider that, she can apply for a reconsideration of the decision. If anyone else wishes us to reconsider it, they can make a referral of any new information to us. At this stage, and I haven't seen the article to which you've just referred, but I have seen the Nottle judgment, and I'm aware of the proceedings in the Federal Court, and I am not aware of any new information that would affect the decision we made.
I want to raise another issue.
I stress it is a different question from the question that is being litigated by Senator Reynolds in the Federal Court.
Commissioner, just to be clear, I'm not suggesting that the matters are the same. So what I'm raising issues about is the process and the determination made by the NAC to close this inquiry when new information is emerging. And just last week, in estimates, we learned that a Department of Finance official who was involved in the settlement, because I've got these documents under FOI, is now involved in running the matter on behalf, or involved in running the matter on behalf of the Commonwealth against Ms Reynolds.
Senator, I think we're straying from the annual report. It is not the role of the committee to go through
No, I'm not. I am not.
Just to be very clear.
Chair, I'm asking a process question, and I'm referring to new evidence which has come to light.
So again, evidence. We're not.
No, I'm not. I'm not inquiring. I'm not asking this committee to inquire into the evidence, Chair. I'm asking about the Commission's processes. When you close a case, you conduct a preliminary investigation, and then, Commissioner, further evidence comes to light. And we've already heard, and even Senator Shoebridge raised this point earlier with the inspector, that the avoidance of a conflict of interest of any public official is critical to public confidence in the government. And so we now, just last week, have learned that an official involved in this matter is now involved in the case against Ms Reynolds in a manner which suggests there is a conflict of interest. So I would ask, perhaps, Commissioner, I'm happy for you to take that on notice and review that further information. But I'm
sorry, Senator, but I don't understand what the question is.
So the question is, when you close a preliminary investigation and when new evidence comes to light, what is the process the Commission uses to determine whether you properly should have closed that inquiry?
Under Section 41(5), we can reconsider a decision at any time. As I have said, if someone asked us to reconsider it, we might. Sometimes we might do so of our own motion. At this stage, I am not aware of any reason why I won't get into the specific case, but as a matter of process, we can reconsider a matter of our own motion, or we can reconsider the matter on request. But I would also stress that under Section 41(7), there is no obligation on us even to consider dealing with a referral, let alone to investigate it.
No, I appreciate that. Thank you, Commissioner. I do want to just go back to the issues with your recusal, and what I would say is the other role that you have, advising the Office of the IGADF. And I did put this to the Inspector. Public confidence in the Commission is obviously critical. Would you agree that managing conflicts of interest also includes managing the perception of conflicts of interest? There's no doubt about that.
Yes, absolutely.
So can I put to you that the optimum way to manage any conflict of interest is not to hold conflicting or dual roles? And given the very important role that you hold as Commissioner of the National Anti-Corruption Commission, can I put to you that it's not appropriate at all that you should be providing any advice to the Office of the IGADF?
Why? The IGADF is a Commonwealth integrity agency. The advice that I'm providing is in a very limited sphere, and it would be utterly absurd if someone couldn't go to Catherine Holmes and ask, look, in your Royal Commission report on robo-debt, you said this came from here or that. We can't find that. Can you point to where that evidence came from? Can you point to the sequence in which things emerge? That's the nature of what I'm being asked to do. And it's fundamentally about a 4.5-year inquiry that only I can answer those questions about.
Well, if your role, and I would put to you, on that inquiry was so critical in terms of your ongoing role advising the Office of the IGADF, then perhaps you shouldn't have taken on the role you're currently occupying as Commissioner of the NAC.
And that's why I put it on the table at the time of my appointment and made clear that I intended to keep on doing it. The time to raise this with me was then, not now.
Well, I've just joined this committee with respect, Commissioner.
And I left a perfectly good job in which I was very happy in the Supreme Court of New South Wales to take this on. It was important to me that I be able to continue to do the very, very modest amount of reserve service that I do now compared to what I have done in the past, and which all governments have always supported.
But I would put to you that your role...
Sorry, we're just at time, so last question.
Yeah. Commissioner, your role is unique in this country. You are the Commissioner of the National Anti-Corruption Commission. And any perception of any conflict of interest surely is an issue.
But
and you've shown that...
Tell me what the conflict is.
Well, you've already accepted that there is a conflict of interest.
Oh, I've accepted that there's a perception.
That's right. And therefore, and doesn't that go to the heart of it?
I don't accept that it's a reasonable perception, but I have stepped away because there is some perception.
Well, doesn't that show a fundamental misunderstanding by you, Commissioner, about your obligation to manage conflicts of interest or perceptions of conflict of interest? Because your initial judgment, I would put to you, is not correct, and you've now had to sort of try and recuse yourself completely. And wouldn't the optimum way to manage this is simply to no longer, or to have never, provided advice to the Office of the IGADF when you are occupying this very important role running our National Anti-Corruption Commission?
I disagree, but it was in order to make sure that there was clarity about that I made very clear at the outset that I intended to continue to do that, and that was the time for someone to say, well, no, that's not appropriate.
But I'm talking about your judgment, Commissioner. I'm asking about your judgment, not for someone else.
These issues. Senator, sorry, I have to give the call to someone else. Senator Darmanin has indicated she will put her questions on notice, so I'll go to Mr Pike. You there, Mr Pike?
We can't hear you.
Just got a question. Commissioner, you did speak to the fact that you didn't see resourcing as the problem behind, obviously we're having a backlog now in terms of caseload. What is the problem then? Is it you've mentioned the retention issues, you've mentioned recruitment challenges. What's the primary problem that's preventing you from, obviously you're meeting KPIs in terms of how they're being set, but what's the main obstacle to you achieving a better level of customer service for those who are coming to the NAC with their issues?
If there were more staff on a sustainable basis in those areas, we would get through the work quicker. Now, we have the capacity we have the resources to recruit the more staff. We're, as I say, I think 30 below our mandated average staffing level. So that's why I say it's not a resource issue. It is recruiting people into those positions and then retaining them that is the significant issue. Did you want to add something to that, GP?
Yeah, thanks, Commissioner. So just following up on the earlier points, Mr Pike, the Commissioner has alluded to the attrition challenges we've had in our early days, and I can talk to the improvements that we've already observed year on year between 24-25 to now 25-26, where you look in aggregate at the Commission as a whole. We had an attrition rate of 26.7% in last financial year, and year to date, as at the 3rd of December, we're observing 14.5%. So our ability to attract and, most importantly, retain staff is improving. And to the points in our triage area, which is under our evaluation branch, they did have significant attrition in 24-25. They were sitting at around 39.5%. And that has since reduced in the year to date to 19.8%. So, building on the Commissioner's evidence, we are putting in place measures that allow us to bring the right people in and keep them for longer, and ultimately contribute to working through the backlog that exists.
Those numbers are very helpful. Thank you for sharing those. That is a very high attrition rate, particularly in that first year for a brand new organisation. I would have thought that would be very concerning. Would you say that any cultural issues within the organisation are leading to those sort of numbers?
I don't think so. In the first year, there was a significant issue in the changeover from ACLI to the NAC. There were some long-term ACLI people who thought that was the end of an era. There were some who perhaps didn't fit into the new organisation and left. So I think that's a significant contributing factor to that high attrition rate in the first year, and my thinking about that tends to be supported by the reduction in the attrition factor for the second year.
Okay. Do you intend to give any thought over the course of the next reporting period to whether the KPIs are fit for purpose? Are there any other things that you should be measuring to determine what your performance? Obviously, it's one thing to meet, for a majority of those who are making contact with the NAC to be able to deal with them quickly. But what concerns us is the state of, for instance, what we saw in the Australian today, where you've got longer-term ones that seem to just not be getting the response that would be expected by this committee.
So we put at the outset quite a lot of effort into working out what the initial KPIs would be, and I say initial because this has always just been a starting point, and we want to get better and more informative KPIs. Ultimately, what we want to do is to measure the impact we have had on improving integrity across the Commonwealth public sector. But getting a measurable for that is, as you would appreciate, really, really difficult. In the area that you were asking a question about earlier of the inspector, about our corruption prevention and education engagements, from about day two I've been saying, is there a way we can do this better than just a mere count of engagements? And a better count would be the audience. What's the size of the audience we reach? So is it an engagement with one person, or an engagement with 100, or is it an engagement with 1,000? But at this stage, a booklet that goes to 1,000 people counts the same as a one-on-one interview with one, and that's far from ideal. So we are very keen on getting more informative KPIs, but I think you'll appreciate that the challenge is just identifying what they might be. Ackley had some that we looked at the outset and didn't think were really useful. So, number of briefs delivered to the CDPP, we didn't think that was a particularly useful measure because we're ultimately about administrative corruption investigations with criminal prosecutions as an offshoot. And so if you've got some ideas, Mr Pike, as to some useful KPIs, I am all ears.
Don't invite me to come up with some. I'll set some for you if you like, but we'll see how we go. But look, if I could just ask you, a couple of years in, if you could rate the performance of the NAC out of 10, I'll leave it here as my final question, Chair. Give us an honest appraisal. Where do you think we're at?
Look, I'd be thinking around the 7 mark.
Very good. Thank you, Chair.
All right, thank you. On that note, we will conclude today's hearing. Thank you for your...
We are listed till 1 o'clock, and I have a few more short questions to put, if that's possible.
Well, as discussed, there are a number of members with more questions, including short questions.
I would invite the committee and the witnesses to extend if necessary.
Well, I think extension's difficult today. We've already lost some members. I am happy to... The Deputy Chair initially indicated that she had an additional question but was willing to put it on notice. But if we're going to go to additional questions, I will extend that offer to her initially. So maybe you can each have one question. But please don't test my
I appreciate that, Chair.
Limits and our patience here.
I'll jump in fast. Thank you, Chair. The Commission's purpose-built hearing room was completed in October 2024, and indeed this committee had a look at it. Your annual report has indicated that it has been used for hearings for over more than 30 days, and the Commission's examined 24 witnesses in private but has not held any public hearings. Commissioner, in 2024 you told this committee that in relation to exceptional circumstances as they relate to public hearings, that you would know it when you see it. Commissioner, have you seen it?
No, not yet.
Okay.
I gave some reasons 12 months ago as to the sort of factors that you'd be looking for, but I haven't seen an exceptional circumstances case yet.
And if I could put to Deputy Commissioner Kilgore, who was reported to have said, the Commission will, and I quote, do a public hearing, we just don't have the right matter. I'm curious as to what processes are in place to identify the right matter.
Dr Haynes, because of the questions you and others ask about this persistently, every time a minute comes to me proposing that I issue a summons for a witness for a hearing, I consider, is this the case? I'm quite keen to have a public hearing, partly to put to rest these continual questions. So I'm pretty keen to have one and say, right, we've done one. But I've got to do that responsibly and lawfully, and not just to get the issue off my back. I've got to have a case that ticks the boxes and which it is going to be appropriate to do it.
I think, Commissioner, the point I'm getting to is what are the processes to determine what ticks the boxes? We don't know what boxes have to be ticked.
Well, I think I listed the relevant considerations in answer to the same question 12 months ago.
I'll leave it there and I'll hand over, Chair.
Senator Shoebridge, 2 minutes.
Thanks, Chair. Commissioner, you earlier referenced the Australian article, which deals with a matter that's been before the NAC. You remember that?
Could you speak up just a little?
You earlier referenced an Australian article which dealt with a matter that's been before the NAC.
You're dropping... I heard you say the Australian article, but you dropped off after that.
Well, I'll say it again. You earlier referenced an Australian article which is published today about a matter that was considered by the NAC.
Yes.
In that article, the survivor of child sexual abuse who went to the NAC with complaints about the AFP had this to say about the NAC. The awful truth is that ordinary victims don't matter to the NAC. My ordeal is testament to that. Every interaction with the NAC was a masterclass in dismissal and plain semantics. It took 2 years for the NAC to forget about evidence, read documents and make a few calls. Unconcerned with my well-being, it took them 2 months to tell me their investigation was finished, and it came with an apology for not using relevant evidence. Do you stand by your 7 out of 10 rating? This is the experience of a survivor of child sexual abuse. Do you stand by that rating?
Yes, I do. That is the experience of one referrer for whom, as I said earlier, I have a great deal of sympathy. It is a case in which we invested substantial effort to engage with that referrer quite regularly, and she obviously has a different perception from that was reported to me by our officer who was engaging with her, and I'm very sorry that those different perceptions exist. But this was a case that came to us in circumstance, or was a complaint about events which had taken place back in 2004. It ticked hardly any of our criteria for an investigation, particularly on account of its age. She asked us to conduct an independent investigation, independent of AFP and TASPOL, and although it ticked hardly any of our criteria, we decided, yes, we will look at this. And we then proceeded to do so with great care in order to see if there was anything at all in the complaint, and a great deal of effort and length was gone to retrieve historical documents from 2 and 3 decades ago from the AFP, to review the prosecution files, to review how decisions were made, to track the employment history of the people involved to see whether they've intersected. And objectively, I think we in fact handled that case as well as it could have been handled in the circumstances.
Well, Commissioner, she doesn't want your sympathy or need your sympathy. She wants the NAC to do a competent job, and in this case, to show critical evidence, photographic evidence to a witness, that after you dismiss the matter, the inspector apologised to her for not undertaking that basic step. She doesn't want your sympathy, wants competence and timeliness, like most people coming before the NAC.
The photograph in question was not shown to the person in question because it was absolutely clear that that person had had nothing to do with the 2004 investigation, and I think if you read the Australian article you will probably find that that statement is in there, although you didn't mention it earlier.
Senator, we are at time. So I'm going to conclude today's hearing, and thank you for your evidence today, and to Hansard and Broadcasting for their assistance. The committee has agreed that any responses to questions on notice should be provided by 20th of January 2026. The committee stands adjourned.